with House Judiciary today, Wednesday, March 12th. Thank you all for being here. Appreciate that. We have 3 bills to work today, or excuse me, to hear today. And then hopefully working one, trying to knock it out. At the end of the committee, I'll talk to the committee more about sort of the plans for the rest of the week. So you know that. But I'm going to go ahead and open the hearing on Senate Bill 70 and ask our reviser, Jason Thompson, to give us a brief of the bill.
All right, thank you, Madam Chair. As you said, Jason Thompson, Revisor's Office. You have hopefully a bill brief for Senate Bill 70 that's as amended by Senate Committee of the Whole, and the bill as amended by Senate Committee of the Whole. So make sure you've got the right version of everything. This is the bill that prohibits fees for electronic copies of records under the Open Records Act. It also exempts from disclosure some formally closed investigations. It requires county or district attorneys to file reports of violations with the Attorney General in October instead of January. It determines the membership calculation of subordinate groups under the Open Meetings Act. It requires public bodies or agencies that live stream meetings to ensure that the public is able to observe those meetings. And lastly, it provides for a 5-minute deviation to resume an open meeting at the conclusion of an executive session. So a number of provisions here and a number of sections, and I'll just try to hit the high points. I know you've got a lot of testimony ahead of you. Section 1 amends KSA 45-219. That is the statute about fees for copies of records. That will look familiar, hopefully, to the committee. You passed HB 2134 on that topic. The amendment here is different than what you passed. I'll just leave it at that. There was a lot in 2134. This has just one provision in this section. It provides on page 2, you can see there that the current law language of 25 cents per page being deemed reasonable becomes a fee for copies which is equal to or less than 25 cents per printed page shall be deemed a reasonable fee. Further, there are additions of no per page or copy fee shall be charged for electronic copies of public records. And finally, if a fee is charged for the cost of staff time required to make information available, no fee for printed copies of those records shall be charged under this paragraph. So kind of a couple of key differences there from 2134, as you probably recall. And I know you've got some testimony about that, at least in the written testimony, and you might have some from folks in person. And obviously, I'll be happy to answer questions later about the differences if you need that. Section 2 is KSA 45-221. You may remember this is the statute that has all of the exceptions to disclosure under the Public Records Act, right? It's 50-some now exceptions to disclosure. The one that's amended here is subsection A. I'm sorry, it's subsection. It is A, I was right. A11, which is about records of agencies involved in administrative adjudications or civil litigation. So right now, you can close those records, or you do not have to disclose those records when disclosure would interfere with a prospective administrative adjudication or civil litigation. That's all the current law provides in that subsection. You'll see on page 4, there are 2 additional provisions added to that. So again, still records of agencies involved in administrative adjudications or civil litigation, compiled in the process of investigating those, and they can be not disclosed if disclosure would reveal the identity of a confidential source or undercover agent. That's a current one, I forgot. The new one is if disclosure, the investigation is formally closed and the agency determines that no violation occurred. So you've got a couple ways to close those records under current law. A new one is added if the investigation is formally closed and there was no violation as found by the agency. Those records would not be public records. They could be not disclosed. I think that covers that provision. I hope I didn't confuse everyone too much with the current law and the proposed law, but if you look on page 4, you can kind of see what's in italics and what's not. Section 3 then gets into the Batterer Intervention Program Certification Unit statute. This one is up in the Attorney General's statute area. There's a current law provision that says, except as otherwise provided by law, certain documents and things done by the Batterer Intervention Unit are confidential. The bill removes the except as otherwise provided by law. So it just makes clear those are confidential as required by state and federal law. There's not an exception otherwise provided by law that needs to be referenced. Section 4 Then gets into another AG statute, 75-753. This is the one that requires county or district attorneys to report all Open Records Act and Open Meetings Act complaints that they receive during the fiscal year. Right now, they're required to report those to the Attorney General by January 15th, and the bill, as amended, moves that to October 15th. So same report, different date. Then the last two sections are both in the Open Meetings Act. The first is 75-4318. There are three new subsections added. I referenced those in the bill brief. They're subsections H, I, and J. You can find them if you want to read them in their context on page 14. So the first subsection provides that when a subcommittee or other subordinate group is created by a public body or an agency, whenever a majority of that subcommittee or group meets, the subcommittee or group is subject to the requirements of the Open Meetings Act. The next subsection provides that unless otherwise stated in law, a private entity is only considered a subordinate group of a legislative or administrative body if the group is under the control, directly or indirectly, of such legislative or administrative body. So that's the second one. And the final one in that section is if a public body or agency voluntarily elects to live stream a meeting, the body shall ensure that all aspects of the open meeting are available through that selected medium for the public to observe. I think you'll hear some testimony about that one in particular. Section 6 then is, again, part of the Open Meetings Act. This is the one that allows you to do closed or executive sessions. And I think some of you are familiar with this. When you do that, you have kind of three requirements you have to meet to go into executive session. You have to have a statement describing what you're going to talk about generally. You have to have the justification for the meeting that's in the statute that allows you to go into that meeting. And third, you have to say when and where your open meeting will resume. So you may recall a revisor standing outside of an executive session, knocking on the door and telling the chair, you said you'd be back at 2:30, it's 2:30, right? That's why we do that, right? Because if you don't come back when you say you come back, arguably a violation of COMA, right? You're supposed to come back into your public meeting. The provision that's added here is to make a specific statutory grace period of 5 minutes. You could come back 5 minutes earlier or later than provided in the motion. So it gives a little bit of flexibility. So an item there for you to consider about those executive sessions. The last thing I forgot to mention at the beginning, like I have been, the Senate did pass this bill after amendments in both the committee and the committee of the whole. The final action vote was 26-14. And I'll stand for questions.
Okay, thank you. Committee, what questions do you have for Jason? Representative Barth.
Madam Chair, Jason, can you tell us all of the bills numbers that these are multiple bills put together, right?
Madam Chair, Representative, it might seem that way, but it's actually just one. It was introduced as one bill with multiple parts concerning open government. I'm not quite sure why the requester in Judiciary wanted it that way. It was Senator Shane. He was the requester in Senate Judiciary that's listed on the website. But yeah, it's all under the subject of open government.
Okay, thank you.
Sure.
Okay, what other questions do you have for Jason? Any others? Just a second. Okay, I think that's good. Yeah, thank you so much. Okay, committee, we have one in-person proponent, Dave Traubert from the Kansas Policy Institute. Welcome to committee.
Thank you, Madam Chair. Members of the committee, I'm Dave Traubert, CEO of Kansas Policy Institute. We supported the changes, the CORA charges changes in Senate Bill 70. We didn't take a position on the other items. We learned subsequently that the Register of Deeds Association had some heartburn over that language. And so we worked out something, we sat down with them, and what they decided was what's in House Bill 2134 on cost satisfies all their needs. So we would be happy, and of course, the compromise on 2134 was worked out with the League of Municipalities. So we'd be happy with whatever you want to bring over from Senate Bill 70 to 2134. Just the costing is what we're concerned about, and everybody seems to be fine with what's in 2134. And with that, I'll stand for questions.
Okay, thank you. Just to be 100% clear, section 1 is the section that you were concerned about, and all the other sections were not. Okay, thank you. Committee, what other questions do you have for Mr. Traubert? Okay, I
Thanks.
think that's it. Yep. Committee, we also have proponent written-only testimony from Audrey Anderson from the Kansas Register of Deeds. And we don't have any opponent testimony, but we do have neutral, 2 that are here in, well, 1 on WebEx and 1 in person. So I will go ahead and call John Goodyear from the League of Kansas Municipalities first. And, oh, yeah, just 1 second. Representative Osmond.
Thank you, Madam Chair. First of all, I apologize. My laptop is updating, which means I can't even access the S Drive or anything else, so that's fun. Just a general question. So as we just heard from the previous proponent, that he is really more interested in the other piece, at least as far as that's concerned. So I'm just curious, who is the general proponent spurring the rest of this bill forward?
So I think it was, from what Jason said, Senator Shane from the Senate is the one that asked for the bill to be, to work with the revisor for it. Is that correct, Jason? Yeah, okay. If you have any more information, that'd be great.
Madam Chair, Jason Thompson, Revisor's Office again. I was just looking at the sup note and checking with research on the history in the Senate side, because I listened to it, but I couldn't recall who the conferees were. But the 5 private citizens were the proponents. So I'm guessing Senator Shane was involved with some of that. Is this right? The Kansas Association of Counties and the League of Kansas Municipalities was also proponent, at least in part. Neutral was the Attorney General, the Kansas Association of School Boards. They asked for some changes. And then also the city of Topeka and Overland Park, which I think you have some from now as well. So mostly private citizens was the answer.
Okay, all right. So thank you for that question. And thank you, Jason, for the answer. So, okay, John, go ahead, come up, introduce yourself. Welcome to committee.
Thank you, Madam Chair, members of the committee. Good afternoon. My name is John Goodyear, and I am the General Counsel for the League of Kansas Municipalities. Grateful to appear before the committee again on a KORA bill. Like Mr. Traubert mentioned, we worked with them extensively after the House Bill 2134 hearing. Senate Bill 70 hearing was actually the exact same day. We supported it, they opposed it, and on 2134, they supported the bill, we opposed it. After those hearings, made sense, let's get together, let's see if we can find some agreement to make this more workable for requesters while still retaining the ability of public agencies to charge what is actual costs. So work together, and it wasn't just the league and KPI, although we were the primary people working it out. We had a number of different cities weighing in, the Association of Counties weighed in. Mr. Klump with the Chiefs Association, the Sheriff's Association weighed in, the Broadcasters Association weighed in, and the school boards took a look at it. So it really was a lot of people taking a look at it. We were grateful to the committee for adopting that agreement that we reached on House Bill 2134, and it moved through the House 123 to nothing. So we would request that if you do move Senate Bill 70, that you just take that section 1 out of the bill and replace it with House Bill 2134. I think that's a good amendment that makes sense for everybody. I will highlight one other section in Senate Bill 70 if you decide to move forward with the rest, sections 4 or 2 through 6. We are neutral or supportive of most of those changes. The one I will highlight is in section 5 of the bill regarding the streaming. Should a public agency choose to stream their meeting, it requires that all aspects of the meeting be streamed. That was brought, I think, if I recall that testimony from that hearing, from a number of different concerned citizens because a public agency wasn't airing their public comment. That is a public part of the meeting. If that agency that had reached out to me, I would have told them that needed to be streamed because it's a public part of the meeting, it should be streamed. But with the language being as specific as it is, it says all aspects of the meeting must be. streamed. There is some concern, if read literally, that a city or other public agency could inadvertently violate this without actually intending to. So say you have somebody presenting and you chose to stream their PowerPoint presentation and not them speaking, have you violated the act? There's argument to be made that as written in the bill, you did. Same goes for if you have somebody at the podium and it takes the camera a little longer to shift back to the council member that speaks afterwards. That's an aspect of the meeting that wasn't actually streamed. So there is some concern that that language would cause inadvertent violations. So we have suggested in our testimony language that the Attorney General's office actually included in their testimony of the Senate Bill 70 hearing, just some clarification on that language. I won't read it, but it's featured in my testimony. This revised wording, according to the Attorney General's office, aligns more closely with their interpretations of and in the understanding of our member cities. We would request that this amendment be considered as well. We believe that it reflects the intent of the new section, but adds the clarity necessary for enforcement and for implementation in our member cities. So thank you for the opportunity to weigh in on Senate Bill 70. Hopefully I answered some of the questions about how we got to the position that we're at. We'd request that if you move forward, that you do take that agreement from House Bill 2134 that you took in that and replace Section 1, and then consider our amendments on Section 5 as well. And with that, Madam Chair, I'll stand for questions.
Okay, thank you so much. What questions do you have for Mr. Goodyear? Representative Barth.
Thank you, Madam Chair. Thank you, Mr. Goodyear. I did read the online testimony from that proponent about the live streaming and public comments. It's referring to Johnson County specifically, and that I have a little part of Johnson County, and that's been an issue that's been brought to my attention by multiple constituents, that they shut off the public comment and live streaming. My question for you is, you said Section 5. Can you point me in the direction of that really quickly, of where it states what you were talking about?
Yes, so thank you, Representative, for the question. It's Section 5 of the bill on its new Section J on page 14, lines 20 through 23. And I don't have the exact language in the bill in front of me, but how we would request replacing it, and we pulled this from the Attorney General's testimony. I mentioned it to their office that we would ask for their amendment, and they seemed to be fine with it. But replacing the language that's currently in the bill with language that says, the open portion of a public meeting shall be made accessible to the public, whether broadcast, live streamed, or attended in person. So it just means that if you're streaming and it's a public portion of the meeting, it still needs to be accessible. It still needs to be online, available for someone to watch. It's just that all aspects language that we were afraid could be a sticking point if read as literally as possible.
I do have a follow-up question too.
Go ahead.
And I don't remember what the statute says for live streaming, because I think it's talking about it being optional, or if they choose to do so and live stream. Is there any current statute or anything at all that says that they should live stream at all? It's just each entity, whether it's a school district or a city or a county or whatever, has the option to not live stream it?
Thank you for the question, Representative. There's nothing in current law that would require that a meeting be streamed. The Open Meetings Act just requires that a meeting be open and accessible to the public. So it's a city. A lot of entities started doing this during COVID. That was where they started streaming it, so they could have open meetings. We weren't allowed to have people in person, so we had streaming capabilities. At the time, the Attorney General adopted some provisional rules and regulations that applied to these streamed meetings. There's nothing in law that requires us to stream them, and there's a lot of entities in the state that can't. They don't have the capacity to do so, but we do have many that have started streaming them.
Okay, thank you.
Committee members, do you have any other questions? So do you have, my question is, who sort of polices, if you will, these Open Meetings Acts? Like, and I know you're not really commenting on the section that has to do with the 5-minute grace period, but who would normally, like in the legislature, we know the revisers are knocking on the door and saying, okay, but in other open meetings, who would be the one that should be enforcing that?
Thank you for the question, Madam Chair. Do you mean who is So by enforcing it,
Like, I mean,
take
if
that
you're
too,
going
but-
into executive session, like a school board meeting or
Huh?
something, and then they're not back, because this bill is saying, let's give them a 5-minute grace period, shorter or longer. But if we don't pass that, or let's say they don't come back after 5 minutes, even after we give them a grace period, who in that meeting is really the one who is supposed to be enforcing the time that they said they'll be gone for executive session?
Sure. So and thank you for the question, Representative. As far as, and I'll just answer both. As far as enforcement, it would be technically a violation of the act, and you could file a complaint with the Attorney General's office or with the county or district attorney. As far as like who makes sure that we actually come back, it's going to vary from entity to entity. With our body, as general counsel, I am the person that makes them go back into an open session. I imagine it's the same for many city attorneys, for county attorneys sitting there. The clerk, anybody that's not in the meeting with, or it could be somebody in the actual meeting with an eye on the clock that says, hey, guys, we need to actually come back out of this.
Yeah.
And
So probably the chair of the meeting is,
yes,
they should be doing that.
There isn't anything in the law that states that's their responsibility per se, but hopefully people are mindful of it.
I guess, I don't know, yeah, so it's curious why, I mean, it'll be interesting when we talk more about this bill as a committee. But I just wanted your opinion on that, your viewpoint. Okay, committee, do you have any other questions? Representative Carmichael?
Thank you, Madam Chair, and I do appreciate the chair's question because I can tell you the 2 state commissions that I served, the chair and the presiding officer, I always consider that to be my responsibility. Now, I appreciated the good advice of staff and council and everybody else, but when we would close the door, I would watch the clock, and I think that's the responsibility ultimately of the person who serves as presiding officer. Now, that's my thought. I don't know what you think, Counselor.
Absolutely, Representative. I appreciate that point of view, and I agree with you, but any violation is going to be a violation of the body itself. So if there's a finding of violation, it doesn't come down to one individual. It's the body that's violated. It's the body that's going to be forced to do some training or the city
Well,
or
and
county that's going to be
it's not
forced
going to be the reviser, and it's not going to be our lawyer.
It is not.
It's going to be the chair and the members who get to pay the fine.
Yep, absolutely.
Okay, thank you. Any other questions, committee? Okay, thank you so much. Appreciate it. We now have Missy Levitt, private citizen via WebEx. Missy, are you with us?
Yes, Madam Chair, can you hear me okay?
We sure can. Welcome to
Awesome.
committee.
Thank you so much, Madam Chair and committee members. Today, I just want to go over a brief summary of my testimony. I wanted to make some comments on Section 1, Section 2, and even though it's not in my written testimony, I provided a little bit of Section 4. So a little bit of the backstory of a core request that I submitted to all of you in my testimony is I'm an election integrity advocate and a researcher, and I found out prior to the primary in 2024 that a lot of election documents are being placed inside the containers with ballots and then subsequently are no longer available to the public because ballot containers are sealed and cannot be opened unless you go to court and a judge orders that. And so that was an issue that I had discovered. And at the August primary, I was a candidate and I'm a precinct person. So I was a poll agent. And about 2 o'clock that afternoon, I went to go get my poll agent credentials. And I was advised that I would be being kicked out of the election at 7 p.m. and that they would not let me look at the tabulator results from the election. And so I kind of went rounds trying to figure out why they had the authority to stop me from seeing the results of the election, plus kick me out before I even showed up. Generally, the rule is unless you're disruptive or anything of that nature, you get to witness the entirety of an election. So they did proceed to kick me out of the election at 7 o'clock. And after that, I went and I filed a complaint with my sheriff's department. The response I got while making the complaint is that, well, I'm sure that someone at the state level is supposed to handle this stuff. And so they did open an investigation, they did conduct some interviews, and nothing ever came of it. But essentially, my statutory privileges were violated, in my opinion, that day, and it is local law enforcement's job to deal with that. And it's unfortunate that local authorities don't understand their role in the election process. They believe it's pretty much the Secretary of State's job or a bigger, larger government's job to police those things.
Yeah, so Ms.
After,
Levitt, can you kind of get us to where you're going with the bill
yes.
specifically?
So,
Thank you.
yes. So in the bill, the core request I sent over is just a blanket core request, which I had to do in order to get pricing for all the things that they will hide from us. So if you'll notice on page 3 of that is all the pricing, and my bill was $4,532. So in section 1 of the bill, I am concerned personally about the video recordings and things of that nature. Texas Congressman Pete Sessions has submitted a bill trying to get recordings of elections for the public, to see. So if we can ever request those, should those become available in the future or part of federal law, it would be nice that we work with that. In section 2 of the bill, especially on page 4, line 38, I don't support that denial of a closed investigation. I would really like to see and request the video of the interview with my county clerk, even though there was no charges filed, because there's no criminal penalties. But it's a matter of personal instance to me, where we're a one-party state where you can record an issue, and I don't feel like it would be a violation of anyone's privacy, a thing of evidence or anything of that nature. So those are the basic 2 things that I didn't appreciate. I do love the part where you guys are taking away the fees for the digital core request. As you can see, $4,532 is a lot of money for us to be able to have access to our public documents. And then lastly, in section 4, I didn't know, is there any type of situation where if the county attorney had gotten a complaint, are they going to be required to disclose that? And if they don't disclose that, then is there some kind of remedy or accountability there? And that was all I had for you all, to make it quick. Sorry. Thank you. I'll stand for questions.
Okay, thank you. I appreciate that, and appreciate you being part of the process here. So committee, Representative Carmichael has a question. Missy.
Thank you. Is it Levitt?
Yes, sir.
Okay. Well, first I want you to know, Ms. Levitt, I appreciate the emails and the information that you regularly provide, and I appreciate your efforts regarding election integrity. To turn to the specific matters at hand, I went through much the same circumstance back about the time of the Bush-Gore election, as far as being a poll agent and not being afforded access when I thought I should have access. And you went through a number of steps, but in response to your question about what do you do when the district attorney, the county attorney doesn't take action, the question to you becomes, did you file a lawsuit? Because CORA does have remedies when people are denied access, when they're charged too much. There's even provisions for award of attorney's fees in some instances. And I know you're not a rich woman, but were you able to file a lawsuit? And if not, why was that remedy ineffective? Why were you not able to do that?
Thank you for the question, Representative. Well, firstly, lawsuits become a pretty big deal in small counties. I try not to go that far. I would rather just have it be a civil thing. But more or less in respect to that part, I guess I was just wondering in section 4 if there was a piece where if the county attorney was not providing the attorney general the proper documentation as prescribed in that section, is there some type of accountability for the county attorney?
I understand your question, but unfortunately, I don't have the answer for you. Thank you, Madam Chair.
Committee, do we have any other questions for Ms. Levitt? Representative Barth has a question.
Thank you, Madam Chair. I appreciate your testimony today. So We did have that House bill that has similar information in it, and there was an area that we were addressing if the amount or the extensiveness of it was so large that they would reach out to that person to talk about it being scaled down to make sure it was meeting the needs. Did that ever happen in the process with you specifically and your request that was over $4,000?
We did a lot of work. I'm sorry. Thank you for the question. We did a lot of work together to scale it down. Ultimately, I just felt like it was important to send you guys this notification that I got because the pricing, even for the printed copies, is a lot. You've got tons of hours on this sheet for employee time, a bunch of redacting time. And so I just wanted everyone to see, you know, some of this particular core request is digital copies. So it would have lessened that. And ultimately, I ended up paying $225 for the tabulator tapes that I should have been able to see in person, which is still a lot. But I just thought that maybe if you guys wanted to go any further and the 25 cents per printed page was, you know, I mean, I pay like $20 an hour for employee time. I don't know how much of that can be worked into the paper fee, printing fee stuff at all, but I just felt like it was the largest core request that I've received and I wanted you all to see it.
Okay, I just want to make sure. It was the answer no?
Well,
No,
and
Like, did they
sorry,
brief
we did work on it and they were always great to work with me on it.
yep, okay.
That's all, thank you.
Yeah, okay, thank you. Any other questions, committee? Okay, we have also, Missy, thank you for being with us. We appreciate it.
Thank you.
We have written only neutral testimony from Matt Bingesser from the Office of the Attorney General, Jay Hall from the Kansas Association of Counties, Michael Koss from the City of Overland Park, and Angela Stahlbaumer from the Kansas Association of School Boards. So make sure you take a look at that written only testimony. Okay, seeing no other testimony for Senate Bill 70, I will go ahead and close that hearing. And I will open the hearing on House Bill 2389 and ask Jason, our advisor, to give us a brief. Yes, 2389, yep.
All right, thank you again, Madam Chair. Jason Thompson, Revisor's Office. So House Bill 2389 comes to you as introduced by Representative Essex on behalf of Representative Williams. So there you go. This is the bill that requires certain prior convictions to be considered in determining bond when a person is arrested for certain sex offenses. You'll see the new provision that is added. We updated this statute. It's kind of in the old style that used the number subsections instead of the letter subsections. So we updated that while we were in here amending this one. So this new subsection is subsection P on page 4, beginning in about line 24 in italics there. It provides that if a defendant is charged with the enumerated offenses, which are rape, criminal sodomy, ag criminal sodomy, sexual battery, ag sexual battery, or indecent liberties with a child, or ag indecent liberties with a child, when setting the amount of an appearance bond and conditions of release for that person charged with those crimes, the magistrate shall consider prior convictions of such offenses or comparable out-of-state convictions. And then there's a section 2 that amends the next statute just to fix a cross-reference because, as I mentioned, we changed the numbering. So that's a little technical cleanup we had to do in that section. It would take effect on July 1st if adopted, and I'll answer questions if I can.
Okay, thank you. Any questions for Jason, our revisor? Okay, I think that's it. Thank you. Okay, I will go ahead and call our proponent testimony. We have our own committee member, Laura Williams, here with us. Welcome to that side of the podium.
Thank you, Madam Chair, and thank you, members of the committee. It's different to be on this side, but I am here to testify as a proponent for House Bill 2389. This piece of legislation that you see before you now has been one that we have tried to craft with shareholders in the community to try to best address some of these issues that are raised when it comes to previously convicted sex offenders committing crimes. So today I am going to share a private citizen's testimony on why this piece of legislation is important to her and advocate on her behalf for a change in policy in the state of Kansas. In November of 2024, at the age of 71, I was attacked in my home by a rapist. Thanks to the around-the-clock efforts of the Overland Park Police, the Wyandotte County SWAT, and the FBI, about 75 to 100 public servants, he was caught 36 hours later and arraigned in Johnson County Court the next day. He was charged with 1 count of rape, 2 counts of aggravated sodomy, 1 count of burglary and theft. I'm told that only 20% of the assaults are stranger and random like mine was. He was apprehended as a result of the DNA that was found in my rape kit. The Johnson County Crime Lab also worked around the clock, and his DNA hit as a previously convicted sex offender. He is 37 from New York City, originally where at the age of 17, he was convicted and served in time in prison for attempted rape of an 11-year-old girl. During his arraignment, he was given a $750,000 bond. I was told that Kansas law requires a judge to issue bail. I would like to change that law to allow the judge at his or her discretion to withhold bail to anyone who has been previously convicted of rape or sodomy. Now, even though in my head told me that he would never be able to make bond, he was previously convicted, he was a flight risk, had no assets and other things. At the time, just 3 days after the attack, my whole being was traumatized again by the thought that he could get out. No one involved at the time knew one way or another if he had a wealthy relative back in New York. Additionally, no one at the time knew that he said he had AIDS and if that was true or not. By the way, he does have AIDS, and as far as I'm concerned, even with today's science, that makes him a walking potential murderer. I believe that bail should be denied to anyone who has previously been convicted of a crime of rape or sodomy, and I urge your support of House Bill 2389. Now, I do want to state with this testimony and her advocating on this policy change and myself as well, this testimony and proposed legislation to consider the current proposed legislation does not offer denying bail for first appearances for certain prior convictions, but is giving discretion for judges to consider prior convictions and setting bail and conditions for release. I have included in my testimony and then in other written pieces of testimony, it does include this language as well. That was crafted after the fact of this piece of legislation, just something for the committee as well to have. I wanted all of you to have that. So thank you for your time and consideration on this issue, and I look forward to working with shareholders to craft legislation that solves the issue of crime and to protect victims in our community. And I'll stand for questions.
Okay, thank you. If it's okay with you, I think we'll go ahead and hear from the next proponent. And then if anyone has any questions for either of you, we'll do it at that time. Thank you for your testimony. Do we have Stephen Howe on WebEx? Okay, DA Howe, are you there?
Yes.
Okay, great. And now we can see you. So welcome back to committee, I should say. And please go ahead with your testimony.
Thank you, Madam Chair and members of this committee for the opportunity to speak as a proponent of this bill. My name is Steve Howe, Johnson County District Attorney. I have been involved in several different functions, statewide committees and initiatives to deal with sex offenders. The first one being the Saki initiative, the Sexual Assault Kit initiative, that was to get rid of the backlog of untested sexual assault kits. Why that is relevant to this bill is I thought it was very important to see the data that came from when we tested those kits and the criminal history results of those offenders who were identified. During that time that I was working on Saki, what we determined is the offenders who were identified on these sexual assault kits, 42% of them committed other sexual offenses, and 93% of them committed other crimes. And if you think about it in those terms, that is a significant indication of recidivism. If you look at the Department of Justice study that was done in 2018, depending on the variables of the cases, somewhere between 35 and 40% of the individuals who commit sexual assaults will commit other types of violent offenses or other sexual assaults. And that was pretty eye-opening when you look at that kind of data, that these individuals have a high propensity to reoffend in other violent offenses. And then one of the things that we saw in the Saki initiative, there was a lot of domestic violence and sexual offenders that mixed and matched between their different types of offenses. And so these violent offenders, as in this case here in my county that you just heard testimony from, these individuals do reoffend at a higher rate. It's also the reason why this body a while back put into place the laws to allow for the Sexual Predator Act and civil commitments for individuals who are high risk. So I applaud this effort to really take from a discretionary view on criminal history to a more you shall consider this when determining bond. Representative Williams is correct that it doesn't prevent bond from being set, and that creates some other legal issues. I think the challenges that I would require some additional effort to have a situation in our state where we have no bond. But in this instance, it makes it more of a mandatory look by the judge in consideration of bond. So I think this is an important thing, because if you look at our sex offenses, especially the ones listed in this bill, they are some of the most serious crimes apart from homicide that we deal with as prosecutors. And if we can protect our community and make sure that we get high bonds and also require those individuals to serve lengthy sentences, we'll be far better off for our community that we serve. And so I'd ask that you pass this bill as a really a common sense public safety measure that can be beneficial for us prosecutors when we go to court asking for bond. And that's all I have. And at the appropriate time, Madam Chair, I'd be happy to answer any questions that anyone may have.
Okay, great. Thank you so much. And committee, what questions you have for either one of our proponents, Representative Carmichael?
Thank you, Madam Chair. Mr. Howe, it's nice to see you again. It seems like it's been nigh on a day.
It's been a long time.
For your information, Mr. Bennett's sitting in the back of the room. So we have two of the finest prosecutors in the state who didn't have anything better to do this afternoon than come to see us. I'm glad both of you are here. Seriously, are there judges who are disregarding these types of prior convictions in setting bond? I just can't imagine that a judge charged with the responsibility of protecting the public safety and evaluating whether or not the defendant is a flight risk would ignore prior convictions for these types of crimes. Is this really happening?
Well, I will say that there has been a concerted effort pushed by the appellate courts to reduce the amount of bonds, surety bonds that are issued in cases. They were adopting the New York model, and that releasing more individuals instead of incarcerating them. And I have crossed swords with the appellate courts on a couple of committee meetings about that. I don't think that's consistent with the views of the people of the state of Kansas when you have repeat offenders being issued PR bonds, because that's the position of what the court should be doing. I think they've backed off that recently when we've seen the disaster of New York and some of the other states that have really pushed these PR bonds and releasing dangerous felons back out on the street. And so that is part of what we've been experiencing, is a real push to have our district courts issue lower bonds. And prosecutors across the state have been fighting back and trying to keep the bonds at a high level for public safety reasons. So there has been prior initiatives that have had an impact on bond settings. And I've seen a huge difference in the last 10 years from what it used to be. And I will tell you, Mr. Carmichael, that I mean, on low-level offenders who have very little criminal history, those people don't stay in jail. They bond out on PR bonds. But when you're talking about these individuals, these dangerous felons who commit sexual assaults and other violent crimes, I think for public safety reasons that we need to have significant bonds in place to protect our public. So that's a roundabout way of answering your question, but I wanted to give a little historical standpoint about how we got to this point.
Madam Chair,
Mhm.
I fear that he didn't understand my question, but we'll still count this as my second question if you wish.
Okay.
Okay.
I thought you'd so wish, Madam Chair. But seriously, notwithstanding what the position is of the Supreme Court Task Force on cash bail or bond and their recommendations, none of which have been adopted, as you know, in part because of your objection and that of other prosecutors, are you telling me that magistrate judges and district court judges are ignoring prior convictions for sodomy, rape, other sexual offenses, and just disregarding that and setting bond without reference to the fact that these people are clearly a flight risk, because if they get convicted again, they're going away for a long time and they're dangerous to the public? Are judges really doing that? And if so, tell me where.
Well,
What counties is that happening in? Who's the judge who's doing something that foolish?
Well, first I would say they're not ignoring it, but when the judge issues his bond, he doesn't set out all the criteria each and every time that he issues bond. So typically what happens is, a judge will ask, what is the defendant's criminal history? And the prosecutor in the courtroom at the time, either first or second appearance, will then announce the criminal history based on the information that we have at that time. And the judge takes that into consideration and then makes a decision. The judge doesn't say, because of these things, every single time, this is why I'm making the decision. So I wouldn't say that they're ignoring that. I'm not saying that at all. I think there's a lot of judges who do factor in prior criminal history in their settings of bonds. But I'm just saying that there's been a concerted effort to drop the levels of the bonds by the courts, and we've seen that impact. But I'm not saying they're disregarding that information. That is incorrect. I would not say that.
Thank you. I appreciate that. And Madam Chair, I wish we had more time. I always enjoy visiting with DA Howe. He's a very smart man, and we have worthwhile conversations. I always appreciate his input.
Great. Okay, committee. I hope you get to spend more time with him. Committee, yes, Representative Schreiber?
Thank you, Madam Chair. And Mr. Howe, you can address this, but I'm sure there's folks on this committee could talk about it too. But when the bill talks about magistrate judges, is that just, I shouldn't say just, but is that a district judge, or do they have specific responsibilities within this system?
Magistrate judges are different than a district court judge, and depending on the jurisdiction, there's varying degrees of responsibilities the magistrate judge will take on. In some of the smaller jurisdictions, you'll have a magistrate judge do quite a significant load of handling cases. Like in our jurisdiction, the first appearance of an individual is handled by the magistrate, and then the magistrate will then assign the case out to the particular district court judge who is given that case. In some jurisdictions, it's the magistrate judge who sets the bond and also hears the case. So it's depending on the size and the number of judges in that particular jurisdiction.
Okay, thank you. I appreciate the explanation. Thank you, Madam Chair.
Yes, and so I think that I have a question follow-up for that one. So the bill talks about magistrate judges. This might be for the revisor. This is particularly magistrate judges. I mean, the amendment that we have talks about the last sentence, the magistrate shall consider prior convictions of such offenses. Okay.
So, Jason Thompson, Revisor's Office. Thank you, Madam Chair. So in Article 22, the Criminal Procedure Code, magistrate has a particular meaning. It means the officer having power to issue the warrant, and it includes justices of the Supreme Court, judges of the Court of Appeals, and judges of district courts. So generally, in this context, it's district court judges.
Includes
magistrate
everybody.
judges, but
Yeah, okay,
that-
that's what I
That
thought.
word has broader meaning than just a magistrate judge.
Okay, thank you. Okay, and Mr. Howe, I do have a quick question, or a question. As I'm looking over this bill, one thing we're not amending is on page 3 of our bill. I don't know if you have it, but it's section, now it's H, it used to be 8, but it lists everything that in determining which conditions of release will reasonably assure appearance and the public safety. And it's just saying the magistrate shall consider all of these things. One of them is, I noticed, record of convictions, and a lot of other things too. So, I mean, is that different than what we're trying to do with this amendment or with this bill?
The only difference would be is if, this is a record of conviction, it's a very generic term, whereas we're being more specific on this. And we all know that the more specific controls over general as far as statutory arguments. And so by doing this, as I said, I think what you're doing is you're re-emphasizing that the court shall consider the sex offenses if there's a prior. If you're in on a sex charge and you have prior sex offenses, the court shall. And so it's almost like an added point of emphasis that the court shall consider that when setting bond. Does the court have discretion already to do that? Yes, but it's almost making it a mandatory option for the court. From a discretionary to a mandatory, you have to consider this as part of your conditions of bond. So it's almost like a double emphasis on this is important for you to consider.
Okay, all right, thank you. Representative Williams, I do have one question. In your testimony, I know the victim was afraid that this individual criminal was going to be released, but do we know what happened? I mean, did the judge consider the prior convictions or not? Do you know?
I'm not familiar with the details of the case or
Okay.
if they were able to meet bail.
Okay. I know
More
she
from
was,
the testimony standpoint.
Madam Chair, I can answer that question.
okay, please go ahead.
He did not make bail, and so he is currently inside our jail, and the case is proceeding and going through the court process as we speak. But I will tell you that when the court rendered its decision on bond, my office did make him aware of the fact that there was a prior conviction. So the court had that as part of their consideration when they set bond.
Okay, great. Thank you. That's helpful. Okay, Representative Martinez.
Do we know how far back are these prior convictions being considered? Like
To Mr. Howe.
yes,
How far back?
how far back are these prior convictions being considered?
Well, we run it through NCIC, which is the federal database for convictions. And so it'll go back your entire history. In some instances, if a person has a juvenile record, it'll also consider that. There are very liberal expungement statutes that are in place in Kansas and other states. Those would still be reflected in our records because law enforcement can see the expungements. So that can go back to as far as juveniles. It can go back 20, 30 years in some instances. And I know from speaking to judges, they typically, I'll give you a good example. If you have a DUI and you get a second DUI, well, if it's been 20 years since you've had your first DUI, the court's going to look at that differently than your last DUI was a year ago, because then it's an indication to the judge you've got a real serious problem versus one where there's a 20-year gap between those convictions. And so while it's not mandated in the statute, I can tell you that's how the courts have typically operated as far as the length of or the span of criminal convictions.
Thank you, Madam Chair.
Committee, do we have any other questions? Okay, I think that is it. Thank you so much for being with us on WebEx, and thank you, Representative Williams. Committee, you will notice there is a plethora of written-only proponent testimony. It's all on the S drive. We didn't print it out. It seemed like we should not. And there were other testimony that we didn't send in, that it had private information on it, so we didn't put it out there either, just so you know about that. But you might want to just take a look and see what all is out there as far as that goes. Okay, since there are no other opponent or neutral testimony, I will go ahead and close the hearing on House Bill 2389. And we will open the hearing on House Bill 2401. And that we will ask Jason Thompson to give us a brief on that.
All right, thank you again, Madam Chair. Jason Thompson, Revisor's Office, House Bill 2401, as introduced by the Chair in Fed and State, provides that prior convictions of a crime that is determined unconstitutional by an appellate court shall not be used for criminal history scoring purposes unless the basis of the determination of unconstitutionality by the appellate court is later overruled or reversed. I'm going to give you the overview here, and I know you've got two very experienced criminal prosecutors and defense folks who are basically going to litigate this issue for you in just a moment. So I'm going to get out of the way as quick as possible. I hope the committee will let me do that. But we're in a sentencing statute here, right? So KSA 21-6810 is part of our revised Sentencing Guidelines Act. So under this statute, it tells you how you calculate your criminal history. And that is used then to place you on the grid that you all have, the laminated grid. This is how you determine the letter that you are, the A through I, right? So we're trying to figure out your criminal history score here. Current law in D9, subsection D9, says prior convictions of a crime defined by a statute that has since been determined unconstitutional by an appellate court is not used for criminal history scoring. So if you have one that's no longer constitutional, you don't count it. Right? So that doesn't go into your criminal history. There's a recent case that says the statute says what it says, and even if that's later reversed, you never count it, right? So once it's unconstitutional, you never count that conviction. At least that's my understanding of the case law as it stands right now. The proposal in the bill is to have an unless added to D9 that says the rule is we won't count it unless an appellate court later overrules or reverses that order. And specifically, it's got to be the Supreme Court of Kansas or the United States Supreme Court that later says that was wrong, that decision was wrong, that statute is constitutional, and then we can count it again. Okay, that's my basic understanding of what was at issue before and what this might do after. And you've got a couple of lawyers that would like to chat with you about whether this is a good or a bad idea. So.
Okay, thank you so much for that. So we will go ahead and begin that litigations, shall we say. And we'll call Mark Bennett, the Sedgwick County, I guess you're representing the County and District Attorneys Association. Welcome to committee. Thank you for coming in person.
There we are. Thank you for having me. So, quick overview. There was a decision made by the Kansas Supreme Court back in 2018, I believe it was, a case called, I think it's pronounced Boetger. It's in my written testimony. And what it said was that this is specifically about a criminal threat count, or the criminal threat statute. Criminal threat has two ways it can be found: intentional or reckless. Supreme Court of Kansas said that we have reviewed appellate court decisions from the Supreme Court and the federal level, and they find that recklessness is not there, and so it's unconstitutional. All you really need to know, I mean, we can get in the weeds about that, that's really not the point, but Kansas Supreme Court said, based upon law, we find a criminal statute in Kansas is unconstitutional. That happened again, I believe, in 2018. I didn't come here in 2018 or 19 to fix that. We accepted that. It's unconstitutional. It's just unconstitutional. You can't fix it. if it's, I mean, you can change the language to comport with the Constitution, but that was the end of it. The change was in 2023 then, the Supreme Court of the United States happened to look at all those cases and said, no, that's not what they mean. It's okay. Again, we can go in the weeds on this, but the takeaway is the basis for why Kansas said that our criminal threat statute was unconstitutional is no longer unconstitutional. So we thought, oh, well, it will resolve itself then. This will get appealed through the Supreme Court of Kansas, and they will say, now in light of the Counterman case, our Boatker decision is overturned, and criminal threat will be fine. 3 weeks ago now, I guess it was, it was Valentine's Day, 14th of February, Supreme Court of Kansas said, we cite to this statute, 6810 D9, and as Jason said a moment ago, if a statute's been held unconstitutional, it's done, and it can never be used as criminal history. And our thought was, well, absolutely, if a statute's unconstitutional, I have no interest in trying to convince anyone to use it for someone's criminal history. But if that statute was later, if the finding was later overturned by the Kansas Supreme Court or the Supreme Court of the United States, then it's no longer unconstitutional, and they should at least consider it. Now, just to finish the thought here, if the Supreme Court of Kansas wants to go back and look at this and say, well, we find it still unconstitutional in Kansas grounds, then I'm done. Fair enough. Maybe I lose criminal threat. But our concern is this notion that this is how the system works. We'll appeal something to the Kansas Court of Appeals, and then they'll sometimes make a decision that a statute's unconstitutional. That will be appealed into the Kansas Supreme Court. So, and then sometimes onto the United States Supreme Court. The process resolves itself, and by the time they're finally done, the last court to decide will resolve it. The last court to decide this issue was the United States Supreme Court, who said this thing should be constitutional again. But we're still not able to use it because our court believes that 6810 answers the question once and for all. Now, I started my written testimony off by citing back to an adage in the law, which comes from the Eckert decision. It's actually much older than that. It says courts must not construe a statute, must construe a statute to avoid unreasonable or absurd results. I don't blame the court for finding this. Maybe they view it as being dispositive, being clear enough, and there's really nothing to argue about. But I don't think that's what this body ever intended, is that a decision, so for instance, the Court of Appeals is the first level of appellate courts in Kansas. They have multiple panels, they call them, of appellate judges. One of those three panel courts could make a decision that a particular statute is unconstitutional. We could then appeal that to the Kansas Supreme Court, and under the Smith ruling, they would say, it's just unconstitutional forever. You can never use it. I don't think that's what we intend here. I don't think that's what the law of 6810 D9 was ever intended to mean. Our guidelines are set up, the guidelines that Jason referred to a moment ago, Mr. Thompson did, the laminated grid that you all have. Very quickly, why do we have that? Because in 1993, before the guidelines went into effect, we had a different system. The guidelines at the time were referred to as truth in sentencing. That's what the adage was that came through the legislature, because they wanted to make sure that we had, when someone got a 3 to 5, they didn't get out in 18 months. When you get sentenced to 204 months, that's your sentence. It's based upon two things: the severity level of the crime and your criminal history, your accurate criminal history. And so I don't think that Smith, I mean, I take it at its word, and the Supreme Court truly believes that 6810 ties their hands. Fair enough. I don't think that's what the intent of the legislature ever was. I think that legislative intent is that criminal convictions that are constitutional, after having gone through the appellate process, are now constitutional, should count. And I've testified, I don't know, 75, 100 times up here over the last 25 years. I don't know that I've ever had one that seemed so clear to me. I understand the argument from the defense. It's an ex post facto violation, something like that. I beg to differ. There's no ex post facto here. If that were the case, then every case ever on appeal, you'll have an ex post facto argument. The bottom line is, when an appellate court when a case goes through the appellate system, The final result should be controlling. And if a statute is constitutional, it should count. It's that simple. And all this does is let the Supreme Court know, no, you can't stop the analysis at 6810 D9. You must go through and determine, has the court reversed or repudiated your earlier ruling? Supreme Court of Kansas could say, no, Counterman didn't, and I'd still lose. Fair enough. But they at least would have to have the ability to go through that analysis. I know this is complicated, and it's probably a little on the arcane side for a 441 on a Wednesday afternoon, but it does matter, and it does have a significant potential impact on criminal histories. If it didn't, we wouldn't both be here at 4:40 on a Wednesday. It really does matter, and I really think it's that clear. I'll stand for any questions.
Okay, thank you so much. I do have a quick question, and then I'll go to questions of the committee. In your testimony on the second page, the second paragraph from the bottom, you gave an example of a rape case with a criminal history, with no criminal history, so can you just kind of tie that a little bit closer to what it is that you're wanting to do here?
So this bill will have no effect, doesn't directly affect sentencing schemes, et cetera. It will allow a judge, though, to consider criminal history. So for an example, the grid, as you guys have it, goes from 10 to 1. So 10s are going to be possession of drug paraphernalia, which is rarely charged. Level 9s are going to be like burglary of a car. 1s are rape, aggravated criminal sodomy, ag kidnapping. The low number on that end, on an I, is 147. Somebody who has no criminal history and does a rape, a violent rape, is looking at a box of 147, 155, 165. That's their sentence. The same person who has prior convictions for person felonies, like criminal threat, if they have 3 of them, they'll be in the A box, the other end of the grid. 653 months, 5 to 54, that's the range. And so the point is, if there's somebody who has prior convictions, that's why I'm up here, because if someone with prior convictions for criminal threat, if they do not count, someone could have 3 prior convictions, they should, 5 years ago, have been an A. Or I guess prior to 18, they'd have been an A, excuse me. Today, they're an I, because under Smith, we can't count them because the Supreme Court in 2018 said they're unconstitutional, and therefore they're unconstitutional forever, never to be counted. So that really does matter.
Yes. So my question is, in that case, in that example you're giving, were the instances of prior rape convictions, why were they considered unconstitutional? Because it seems like to me what I hear you saying is, if the courts had found that crime to be the Betger case,
Right.
so if it was intentional or reckless. So, but I don't understand. I mean, this clearly seems like these should be counted anyway, but what does that have to do with the prior cases and the new appellate decision that came out?
Make sure I understand your question.
Okay,
Don't
and
answer
if
it.
there's someone else
No,
that can
this
answer
is
better
very-
than me.
I mean, this is very granular.
So, okay,
Oh.
so what the Supreme Court decision and their Smith decision said, a prior conviction of a crime defined by a statute that has since been determined unconstitutional. But what in rape has been considered unconstitutional? Okay,
No application to rape. It has I'm a guy who's been convicted of rape, standing here in front of a judge. What's your criminal history? He has 3 prior convictions for criminal threat. He's been convicted on 3 occasions, or 3 times on 1 occasion. He has 3 convictions for the felony of criminal threat. That's a person felony. And because of this decision called Boatger, a judge today cannot consider those. So he has to sentence him as an I
see.
not as an A.
Okay, and so it's the criminal threat that, like, if his conviction had been criminal threat with the mens rea of recklessness.
I just use rape as an example.
Okay, I got a little hung up on that for just
No.
a second, so, okay.
Doesn't matter what I'm standing before you as, you're the judge, I'm the defendant.
But it's about
It's my criminal
criminal-
history is all I'm talking about.
specifically criminal threat.
Yes. But my point is too, it's not just this, well, it's just criminal threat, this won't be repeated again. What if there's another decision by a Court of Appeals panel that finds another statute at some point unconstitutional, a criminal statute? According to Smith, that's it. we're done. And if we appeal and go, whoa, whoa, you got this wrong, we appeal it to the Supreme Court of Kansas or the Supreme Court of the United States, who says, no, there's nothing unconstitutional about that, that's fine. Smith says, too late.
Okay, I understand. Yep. Thank you for that explanation. I was missing a little bit of it. Okay, Representative Lewis, you have a question.
Maybe we'll get into this, but you mentioned ex post facto. Doesn't that just apply to convictions or trials of a particular defendant? It really doesn't go more broadly than that.
To me, ex post facto is the law that I'm subject to today is changed in the future. I can't be held accountable for what happens in the future for what I did today.
Right.
This is an appellate decision. I mean, cases get appealed all the time, get reversed, sustained, et cetera. So as a very general matter, I agree with your statement.
Right. Okay, I think I copy.
Representative Osman.
Thank you very much, Madam Chairwoman. I'd like to try to get an understanding of the context as to the language itself, because it seems to be narrow. So
in the proposal?
In the proposal, the modification that's being made seems to be narrowly tailored to a particular instance. So let me ask, is this to try to just clarify legislative intent over a particular case? Or what is the wider applicability of this change in language?
Well, I wouldn't be here if it wasn't for Smith and Boatger. So yes, it is specifically designed for this, but we're trying to keep it narrow enough that it could be applied though, or broad enough and narrow enough at the same time. It's a balance, so that it could be applied in the future should there, let's say that the Supreme Court next week decides that some manner of DUIs is unconstitutionally overbroad. So DUI statute, according to let's start with the Court of Appeals. The Court of Appeals panel says DUI 1567 under whatever subsection, that's unconstitutional because it's overly broad. The AG's office appeals to the Kansas Supreme Court, who says Court of Appeals got it wrong, it's not unconstitutional. Under the Smith decision, this rule would say, I think not suggest, it says clearly, because it was found unconstitutional, it's just unconstitutional when it comes to criminal history. And all those DUIs could never count on criminal history in the future. And my point to that is whether it's criminal threat or DUI or anything else in the future, I don't think that was ever the intent either of the guidelines or certainly the criminal or the legislative intent when they passed this subsection. So we're trying to not Katie bar the door, but simply say only when there has been a reversal, a subsequent reversal or repudiation of an appellate court's holding that a statute is unconstitutional, then the Supreme Court would have to at least analyze it. They couldn't say, we're done, 6810D bars us. As I said a moment ago, they could still come back on this one and go, nah, we still find it unconstitutional. Fine. But they'll have to go through the analysis. 6810D, the way they've interpreted it in Smith, says we're done. We can't even consider, we can't even address whether or not the Supreme Court of the United States has overturned it.
Representative Lewis.
So, and what was the rationale for the state Supreme Court decision?
Federal law. And I can go into the details, but it's basically they found that recklessness should not have been a basis for criminal threat. Criminal threat is defined as either an intentional or reckless act. And the Supreme Court of Kansas said recklessness is bad because federal appellate court said so. They weren't wrong. It's just that 5 years later, in 23, under this counterman or counterman, something like that, the Supreme Court of the United States overturned all that case law that Kansas had relied upon. And so resolves the issue for me. The Supreme Court could still disagree, but they didn't take it up. They didn't even consider, they didn't go through the analysis because they didn't think they could because of the statute.
So it wasn't grounded in ex post facto.
That had nothing to do, as far as I know.
So if we pass this bill, Might the defendants argue that it's violation of ex post facto?
Good, I don't know on what basis, but they could. And fair enough, they do and they win. All this bill does is require the Supreme Court of Kansas to at least go through the analysis.
All right, thank you.
Representative Vaughn.
Thank you, Madam Chair, and thank you for your testimony. This may be the ex post facto argument, and I'm not understanding, but I guess I'm trying to understand when the statute would become controlling. So under the current ruling, would it still be, people who, I'm trying to think how to phrase this, who were convicted or who.
I think I know where you're headed. Let me, yeah, there's a rule of appellate law. There's kind of a finality rule. Once your appeal's done, it's done. If a law changes next week, we don't go back and review cases from the 60s and 70s. The only thing I believe, and counsel can tell me I'm wrong, but the only thing I believe that would be applied here is cases that are still on appeal. If a case is in judgment and in 2018 somebody was sentenced as an I who had criminal history, including criminal threats, I don't believe I have any ability to go back and undo that. If the appeal is final, it's final. But when appeals are on, are still open, sometimes I say still on the pipe, or for future reference, then the court would have the ability to at least address that. Does that answer, is that what you're getting at?
It does, actually, yes. Thank you for addressing that.
I just want to be sure.
I was going to be disappointed if you didn't have a question for me, John.
Representative Carmichael.
Thank you, Madam Chair. Quite honestly, Mr. Bennett, the major reason I asked for recognition is because I want to tell you how much I appreciate your work, despite the fact that some of my constituents and some of my friends don't like some hard decisions you've had to make as to whether to prosecute or not. As far as I'm concerned, you can be my DA for life, and Jeff can be my sheriff for life.
My wife might disagree.
Well, it sure makes it a lot easier for us Democrats recruiting candidates because we don't need to worry about recruiting somebody to run for DA because you're the DA. So there you go.
You were wanting something from me, aren't you, John?
Actually, I don't. But rather than try to ask my questions of you, let's hear from Ms. Brandt and the people from the Public Defender's Office bids because they may answer my questions in the process. But thank you, Mark. I appreciate your work.
Let me just make sure. Does anyone else in the committee have a question for Mr. Bennett? Okay. All right. Thank you so much. Okay. We will now call up Emily Brandt from BID's Legislative Committee. Welcome back to committee. And we are so interested to hear what you have to say.
Good afternoon, everyone. Emily Brandt with the BID's Legislative Committee. I will try to remind myself that you are not a hot appellate bench and you are a body of legislators, but it sure feels like a appellate oral argument. So yeah, we're here in opposition to House Bill 2401. I guess I will also call it Boatger. I'm not totally sure how to pronounce it either. I think our biggest takeaway here is that this legislation is currently unnecessary, and it's currently a rush to change a statute in response to a Kansas Supreme Court case. There are frankly several outstanding questions about criminal threat in the state of Kansas. Again, I think that we share a difference of opinion here. We would not agree that Counterman has said that reckless criminal threats can now be counted in a person's criminal history in the state of Kansas. So we would not agree that there is now United States Supreme Court case law that says Kansas's criminal threat statute is again constitutional. Smith didn't address that. There is a pending case in front of the Kansas Supreme Court right now, State v. Phipps. We've cited to it in our testimony here. And State v. Phipps was a Court of Appeals opinion. They held that Bottger did overrule Counterman, or that Counterman did overrule Bottger, sorry. But that case is not final. It's pending before the Kansas Supreme Court. I think before we change this statute, we should at the very least allow the Kansas Supreme Court to have the final say. We would also disagree with the point that if the Kansas Court of Appeals says a statute is unconstitutional, and then the Kansas Supreme Court says, well, you guys got that wrong, that's a constitutional statute, that it can just forever not be counted in a criminal defendant's criminal history score,
That's not how finality of cases work. If the Kansas Court of Appeals says that a statute is unconstitutional and it's appealed to the Kansas Supreme Court, that case is not final. It's not binding on district courts in the state of Kansas because it's pending before the Kansas Supreme Court. So if the Kansas Supreme Court takes it up and says, no, that's a constitutional statute, I mean, it's sort of like that Kansas Court of Appeals opinion didn't happen because it was never final. It didn't actually find any statutes unconstitutional. So I just think again, the biggest takeaway here is just that this is premature legislation. It's hurried legislation. It's rushed legislation in response to something that happened 3 weeks ago. And I think it's going to create all kinds of appellate litigation, which, you know, is nice for job security, but if I don't have to litigate criminal history challenges, I don't really want to. I certainly, if you think about, you know, it says if the Kansas Supreme Court does it, or if maybe the United States Supreme Court does it. So, I mean, are we now going to be litigating? We're going to have people who are like, well, I think Counterman overruled Botker, or that Counterman says our criminal threat statute is constitutional again, so we're going to start counting them. But we don't have any Kansas Supreme Court case law that says Counterman was overruled, or that Botker was overruled, so do we follow Counterman? Do we wait for the Kansas Supreme Court to apply Counterman and overrule Botker? I just think it puts us in a weird position where I don't think that this provides any clarity to sentencing courts. 216810D as drafted provides clarity for sentencing courts. If a statute has been declared unconstitutional, any convictions under that statute cannot count in somebody's criminal history. And then to say that there's nothing that can be done about that, that's not true. This body could amend the statute. I believe that there has been at least one proposal since 2019, really since 2020, because the state did cert petition Botker up to the United States Supreme Court, and the United States Supreme Court declined to hear it. So there has been at least one bill introduced in this body since then to amend the criminal threat statute to take out any reference to reckless criminal threat. So it's not true that you could never count those convictions again. This body could amend statutes so that they meet constitutional muster, and then they would then count in a person's criminal history. So I think that there are other ways around the issue that are not going to inject uncertainty into this sentencing provision, particularly when it really is just about criminal threat. But primarily, it just seems rushed. We still have outstanding questions about Botker, about Counterman, about whether or not there is an independent state law reason why reckless criminal threats should be unconstitutional. The Colorado statute is very unlike the Kansas statute. So it's not actually clear that Counterman does overrule Botker or that it's applicable to Botker. So we would respectfully ask this committee not to work 2401 and at the very least wait until we have resolved some of these issues by Kansas Supreme Court opinion, possibly in FIPS. And I know that there are others pending out there because we are litigating criminal threats. We are always litigating criminal threats. So I'll stand for any questions that this body might have.
Okay, thank you so much. Committee, what questions do you have for Ms. Brandt? Representative Carmichael?
Thank you, Madam Chair. I think I understand the question I'm about to ask, but if I don't, help me, okay? If Counterman overruled the precedents, if it did, then why doesn't the Kansas Supreme Court disregard ASA 2168 or I shouldn't say they did disregard because I don't think they've even gotten to it yet, but would the Kansas Supreme Court just follow Counterman, or do they look at our statute and try to determine whether or not Counterman in fact overrules it before they strike it off the books? There's our former colleague, Representative Carl Mon. Nice to see you, Representative.
Representative Carmichael, Madam Chair, thank you for your question. I'll do my best to address it here. Again, we don't know that Counterman overrules Botker. We're awaiting that decision. If our Kansas Supreme Court says that Counterman does overrule Botker, then I think that this body has drafted 216810D9 in such a way that I think they're looking for ways to create finality and to create clarity for district courts. And so if they have ever, or a final non-appealed Kansas Court of Appeals decision has held that a statute is unconstitutional, it just can't count for criminal history scoring purposes. And that just makes it easier for district courts and PSI writers, pre-sentence investigating reports, to calculate somebody's criminal history score. It's not like somebody can't be convicted under that statute. Certainly they can. It just means that when we're scoring their criminal history, we're not going to count it. And part of that is like we then have like weird gaps in time. So it's like if I committed my crime after Counterman, but before the Kansas Supreme Court said that Botker was overruled because of Counterman, does my prior criminal threat count? Or if I committed my crime before Botker, does my prior criminal threat count? It just creates this hassle and this unnecessary sort of like math, and quite frankly creates appellate litigation when you're trying to determine what priors in somebody's criminal history score counts. If the Kansas Supreme Court comes out in FIPS and says, Botker's no good, reckless criminal threats count, prosecutors can start charging people with reckless criminal threats again. They can be convicted of reckless criminal threats. They just won't be scored in their criminal history to determine where they fall on the sentencing grid. And I think that that is for finality and clarity for sentencing court judges. And it creates finality of sentences because when you score questionable convictions in somebody's criminal history score, those get appealed. Those create appellate litigation. And I'll tell you that a lot of people have criminal threats in their criminal history score because guess what? They're low-level felonies. They're severity level 9 felonies. So it's very easy for prosecutors to plead people down from higher severity level crimes to a severity level 9, say you're going to get probation, but you're going to have a person felony in your criminal history now. So they bump people up through their criminal history. And so this happens a lot. We see it in a lot of people's criminal history. I think that this body's intent of 216810D9 was to create finality of sentences. And so just never scoring them in criminal history creates finality. It doesn't leave ambiguity. It doesn't create appellate litigation. It creates presumptive final sentences. So I think that that's what this body's intent was.
Committee, what other questions do we have? I might ask one question just about the language of the bill that's in front of us. You know, you're saying the Colorado countryman decision may or may not apply to us because our statutes are written differently. But so what's the harm of this bill? Because it's not mentioning that. It's just saying if that eventually does happen, it might not even be countryman, but if there was a appellate court decision that was overruled or reversed, then you would be able to count it. So it seems to me it's not dependent necessarily on that. It's sort of more of a bigger picture, how we want to go forward.
Right, thank you for your question, Madam Chair. So I think the harm is as it's written, right? It says, unless it's later overruled or reversed by an order or opinion of the Supreme Court or the state of Kansas or the United States Supreme Court. And so I think, and again, I'm only speaking about criminal threat because that's what this is about. So I'll continue to use that as an example and then try to make it broader here. But the question becomes, can prosecutors now argue that the Supreme Court under Counterman has found that reckless criminal threats are constitutional, so the Kansas statute is constitutional, so we're counting them, despite the fact that we have no Kansas Supreme Court case law that says Botker is overturned, and so our reckless criminal threat statute is constitutional again. And so I think that that's the harm, is that we have competing bodies, competing final arbiters of the Constitution that I think leaves ambiguity. And again, this is specifically for district court judges who are doing sentencings, people who are creating PSIs. They don't know, I think, whether or not to count prior convictions of a statute that's been ruled unconstitutional. Maybe some PSI writers are going to include prior criminal threats and criminal history as scorable because they say, well, Counterman said that we could count reckless criminal threats. And then we might have some other PSI writers that are like, well, the Kansas Supreme Court hasn't overruled Botker yet, so I'm not going to count the criminal threats. And so I think it creates ambiguities, it creates confusion, and it creates, quite frankly, unfair sentences. The entire point of the sentencing scheme is that people receive consistent sentences based on the severity level of their offenses and their criminal history. If we have some counties that are counting criminal threats and some counties that are not counting criminal threats and criminal history, that makes sentences uneven for the exact same crime. Because again, they're person felonies. You jump from I to D to B to A. I mean, you go up exponentially if those are counted. And so I think that that's where the harm is created, is that 216810D9 as drafted creates finality and clarity for sentencing court judges and PSI writers. This injects confusion and ambiguity and leaves up for interpretation whether or not convictions are going to count in somebody's criminal history.
Okay, yeah, thanks. Committee, do you have any other questions for Ms. Brandt? For Ms. Brandt, Representative Boheim.
Thank you very much. Could you just estimate how many cases you think that this could affect?
I could not. I could see if somebody in our agency could, but yeah.
Be helpful, thank you.
Yep, great, thank you. Yeah, so we do have a question for him, so I'd like to go ahead and finish, if it's okay with Ms. Brandt. Representative Lewis.
So in this case, the appellate court determined that the criminal threat statute was unconstitutional. Is that right?
Representative Lewis, thank you for your question. In Botker, is that what you're talking about?
The case that the appellate, yes, there was an appellate court decision that determined it was unconstitutional, right?
Yes, the Kansas Supreme Court did in 2019.
I thought it was an appellate court.
That was
an intermediate appellate court.
right.
Okay.
No, that was the Kansas Supreme Court.
Okay, maybe I'm misunderstanding then.
Yeah, Botker, State v. Botker, the case site is 310 Kansas 800 2019. That's a Kansas Supreme Court case.
And then later, the U.S. Supreme Court arguably said the basis for that decision was wrong.
They said that under the Colorado statute, reckless criminal threat was an accurate mens rea.
Right. And so arguably that concerned the basis for the Kansas Supreme Court decision.
Which is currently pending before the Kansas Supreme Court in State v. Phipps, because there's a Kansas Court of Appeals decision, 63 Canap 2D 698, which is cited in our testimony, that held that Counterman overruled Botker. That was petitioned to the Kansas Supreme Court. It was argued in front of the Kansas Supreme Court. It's still pending, which is part of why we think that this particular bill is rushed.
And so that's a separate case.
It's a separate case.
Right. So a prosecutor looking at the Kansas Supreme Court decision and the U.S. Supreme Court decision thought that, oh no, our criminal threat statute's still good, and therefore brought the case. No.
Which case? I'm so sorry. Smith? Are we talking about?
I don't know the names.
Okay. Well, I think the biggest problem is that, again, this body never amended the criminal threat statute. And so criminal threat is it just says intentional or reckless. And so when prosecutors bring criminal threat convictions, they just say we're charging it under whatever the statute is, A1. And that's as reckless or intentional. So the conviction is almost always for intentional criminal threat, but we don't know that based on the statute, because the statute includes both mens reas. And when you're scoring people's criminal history, it's sometimes difficult to know whether or not they were convicted of intentional criminal threat or reckless criminal threat, because the journal entry of judgment just says the statute number and it includes both. And so that's why I think that as written, 6810D9 serves its purpose. It's not about future convictions, it's not about et cetera. It is about finality for counting convictions in people's criminal history. It's already litigated all the time, and I think this will probably just inject more litigation about whether or not those convictions count. Because again, right now, sometimes you don't know in somebody's criminal history whether or not they were convicted of intentional or reckless criminal threat. It could have been intentional, but we don't know that, so we litigate whether or not it was intentional or reckless, just for criminal history score purposes.
Thank you. I'm really confused, and I'll just have to study the documents and maybe come up with more intelligent questions. Thank you.
Yeah, I am happy to answer questions by email, et cetera, too.
Thank you. We appreciate that. Yeah, thank you. I think we do have a question for Mr. Bennett. Yeah. Thank you, Ms. Brandt. Appreciate it. Someone can ask you a question after this if anyone has one. We'll go back and forth.
Thank you very much, Madam Chairwoman, for indulging me. So I think you've done a really good job of explaining the importance of this and why it's, what it helps to clarify in the law. And I think that Ms. Brandt also, had a very good point as far as the question of rushed legislation. So let me ask this. We're in year one of a 2-year legislative cycle. And were this to just remain in committee, we could address it next year. Talk to me about what is the harm of having this into law in 2026?
Two things. It is rushed, and it's because 3 weeks ago they said the following. I thought, this seems so strident. I thought maybe I got it wrong. So I just looked it up again. Page 37 of the Smith decision, if you want to look it up. And I'm going to try to just knock the fog from the room and just cut to why I'm here and why it does matter this year. The Supreme Court in its Smith decision said, it was talking about, I put this on page 2 in a highlighted portion of my written testimony. But it says here in the decision, they're acknowledging that the parties are arguing over this counterman decision and whether or not it overrules Boatker, which really gets to the question Representative Lewis just asked. What the Supreme Court said is 6810 D9 provides, and it reads it, it says, this is the part that is so important, under the plain language of this subsection, it is irrelevant whether a subsequent appellate court reversed or repudiated an appellate court's holding that the statute is unconstitutional. I don't disagree with her that it could be that Kansas says counterman doesn't control and Boatker's still good law and criminal threats still shouldn't count. Fair enough. That's the process. I live with that every day. The Supreme Court said, no, 6810 says it's irrelevant. We don't even have to consider it. I know about FIPS. We were hoping FIPS would resolve it. I have no reason to think that at this point that based on the Smith decision that the FIPS court's ever going to get to it because they're going to read their own language from February 14th and go, it's irrelevant whether the Supreme Court ruled because 6810 rules the day. That's it. As to your question, ma'am, how many cases? I don't know today, but I know in 2018 we did a quick summary, and I asked and confirmed this last week. Ms. Chalmers, who's the Deputy Solicitor General for Attorney General Kobach. How many cases are affected by this? She said, well, we don't know today. I haven't done a quick, in the last 3 weeks, nobody's run the numbers, but in 2018, there were 5,000 people convicted of criminal threats. Not all in prison, not all on paper, but they had those criminal histories. If they go out and commit new crimes tomorrow, under this, those counts do not count when they stand before a future judge. Whether they should or they shouldn't, the Supreme Court needs to tell us. But 6810 stops them. It's that simple.
Representative Vaughn.
Thank you, Madam Chair. I guess 2 questions. So I'm trying to understand the nature of the current Kansas Supreme Court case. So you're saying that they would just dismiss it on the grounds of this statute, that it can't be, that under Smith, that it wouldn't be considered. But my understanding based on Ms. Brandt's argument is that they're deciding whether counterman controls Botner, and that would be a different decision, wouldn't it?
All I'm saying is that maybe they will, but 3 weeks ago they said it's irrelevant, and they literally addressed counterman, said the state is arguing that counterman overruled Botker, and they said, I'm not paraphrasing, I'm quoting directly. They said in response to the state's argument that counterman overturned Botker, they said it is irrelevant under the plain language. I'll say it again, so I don't want to misquote the Supreme Court. Under the plain language of this subsection, it is irrelevant whether a subsequent appellate court reversed or repudiated an appellate court's holding that a statute is unconstitutional. So while hope springs eternal, I hope she's right. I hope when FIPS comes up, they take it up and decide whether counterman controls and overturns Boatker or not. I'm just simply saying that 3 weeks ago they said it's irrelevant. I don't have any reason to stand here and tell you that there's reason to hope that the Supreme Court's going to take a different tack in 3 weeks than they did 3 weeks ago. They seem to truly believe their hands are tied by 6810 D9. And all I'm asking is to say they're not tied. Add this language here. If it's overruled, you can still decide. I might lose, but I would at least know from the Supreme Court.
Yes, go ahead.
I guess my concern, so I understand your point that why would they make a different decision? But my concern would be, okay, so we passed this law. They can consider different decisions. So sentencing guidelines start using that for determining, again, I'm using the best language I can, but so they start considering this when they start considering criminal threat when determining sentences. But then we have a Supreme Court decision that does decide to take up that question, and they decide Botner's ruling or rules, and that criminal threat is unconstitutional. So then there's this back and forth of what is and isn't constitutional.
I won't be back. We weren't here after 2018 when Boetker was decided. You never heard from us. We might change the criminal threat statute for future reference, but I can never go back and undo it at that point. Yes, appellate decisions affect criminal history, affect all kinds of things along the way. I'm just asking for an opportunity for the Supreme Court to make that decision.
Okay, thank you.
Representative Barrett.
Thank you, Madam Chair. And I know we've talked a lot about this case because obviously it's what brought it on, but just touch on for a minute. I mean, this also will affect future cases, right? I mean, that's important to note that this one's a little messy, but in the future it could be pretty, clear cut. The state Supreme Court could decide something and the U.S. Supreme Court says, no, that's incorrect. And then retroactively we could.
To her point, we could go in and say, let's not do this, let's just fix criminal threat. Fair enough. I mean, all we have to do for criminal threat moving forward is just charge it under the intentional side of things, and I don't worry about reckless, and that's what we're doing. But a guy who's convicted, who's charged of any crime in the future, I used rape because it's just stark, the difference between an A and an I is there. Burglary, level 7, low number is going to be 5 months, top number is 34. If I am convicted of burglary in 3 weeks and this isn't resolved, my judge's duty bound to say you're an I, even if I have 3 priors, 2 priors for criminal threat. And to her point, criminal threat is one of the most utilized statutes we have. I didn't want to make this all about criminal threat because it applies to, it's a general rule of law I'm talking about here. But to the point, 5,000 cases, why so many? She's not wrong. Domestic violence cases, all the time. I said it, by the way, you can write it down, you're not wrong. Domestic violence cases, they come in, she doesn't want to testify. He's there, we offer a crim threat, he avoids the trial, he avoids more serious charge. It is utilized all the time, so it affects a ton of folks. But to your point, in the future, yes, it'll have an impact on criminal histories moving forward.
Okay, do we have any other questions? Representative Barth.
Thank you, Madam Chair, and thank you, District Attorney Bennett. So I feel like everybody's got this clear as mud a little bit here, but And I did look up at the statute and, I scrolled to where it has its, a number 9, and it is very simple. And I think what you're saying though is that just that line, number 9, does not say that they can't go to another court. Is that what I'm understanding the challenge is, that it doesn't specifically say that?
With the Supreme Court of Kansas, the way they've interpreted that line as of 3 weeks ago is to say that because of that line, if any criminal statute has been held unconstitutional, we're done. Okay. And it is irrelevant, I'm using their language, it's irrelevant whether another appellate court down the road overruled that and said, no, you can't, it's okay. No, it's such the plain language of the statute says this Kansas Supreme Court means we're done. And I'm simply asking for a provision that allows them to say, no, we must do further analysis. Clear as thick mud?
No, I think I got it now, so I appreciate it.
Okay. I'm sorry, this is such a
This is interesting. I mean, we're trying to get a grasp, I think. Okay, I do think that we have another question for Ms. Brandt, but first, any other questions? This is the last call for Mr. Bennett. Okay, thank you so much. And I believe Representative Vaughn, Ms. Brandt has a question for you.
Thank you, Madam Chair. Thank you, Ms. Brandt. I just wanted your perspective on what Mr. Bennett had said. If you think, I mean, what are your thoughts on whether the ruling in Smith that the Supreme Court would come back and say that we're not going to take up deciding the decision about Counterman and Botner because it's irrelevant, that, this is what our law says, therefore we're not going to litigate this case. Do you think that's a likely outcome? What are your thoughts on that?
I don't know if that's a likely outcome. I try not to, as you guys might know, I lose a lot in the Court of Appeals, so I try not to crystal ball anything that they do to get my hopes up. But again, we currently don't have any, it's pending. They could do anything. I mean, quite frankly, they could flip Smith in FIPS if they wanted to. They're entitled to do that. It's their jurisprudence. And so that's primarily why we think that this is a little bit rushed. We just sort of don't know. This isn't settled. Again, I appreciate Representative Barrett's concerns. Like, this could have broader implications, but right now it just doesn't. This is truly about criminal threats. And again, this is about criminal threats and criminal history. This isn't about criminal threat convictions. And this body has options available to it. If it doesn't like that we're not counting criminal threats in people's criminal history, it could have at any time after Boker became final, amended the criminal threat statute so that it said it's just intentional criminal threats. If FIPS comes out and says Botker is overruled and reckless criminal threats, you can charge and prosecute them again, this body can again amend the statute, and then those would start counting again. You would suddenly have a constitutional statute. So I don't think that it is so black and white that we're just never going to consider it. There's no way around it. There's nothing we can do. This body has options available to it, and I think the intent, again, of 2168-09D, or yeah, 2168-10D9 is to create an easy way for PSI writers and sentencing courts to calculate somebody's criminal history so that criminal histories are applied fairly, consistently across all 105 counties in the state of Kansas. This has nothing to do with whether or not you can charge or prosecute or convict or sentence someone for criminal threats. It has nothing to do with whether or not this body amends the criminal threat statute such that it complies with the Constitution again and can count in criminal threats. This is just about scoring them for criminal history purposes, and it creates an easy rule for sentencing courts and PSI writers to follow.
Thank you.
Okay, thank you so much. Appreciate that. Okay, committee, we do not have any other proponents or opponents, no neutral. So I will close the hearing on 2401. Thank you for the very robust discussion. That was interesting. Okay, committee, what I would like to ask you is, I would like to work even possibly 3 bills right now. Here's my question. Tomorrow we have a really big hearing. It's the Senate resolution about judicial selection. I would like to work some bills tomorrow. Here's my question. Are you okay staying a little later tonight and maybe tomorrow working some bills? Or would you rather work on Friday? And I'm Representative Barth, were you gonna say something? If you promise to come back. Does anyone have any other? It's 3 bills. We're not bundling anything, just so you know. I don't think they're super controversial. Work? Okay, everyone's okay? Okay, let's try that. And then I would even like to maybe work a couple of easier type bills before the hearing tomorrow and just kind of get that done. Okay. Representative Curtis agrees wholeheartedly. Okay, thank you so much. Okay, committee, I'd like to work Senate Bill 30, which we heard on Monday, on March 10th. It is the bill about fingerprinting that the Department of Labor talked to us about, and then we have an amendment. If you recall, they wanted to add in the fire chiefs, bank commissioner. Yes.
Are we going right now?
She left to go. Yeah, she's coming back. Okay, do we need to take a 2-minute break? I'm good. Yes, yes. I know, that's what I'm afraid of. That's what I'm afraid of. Yeah, okay. All right, let's go ahead. Yeah, no, she'll catch up. So, okay, we're gonna talk about Senate Bill 30 first. I do have an amendment that I guess I'll go ahead and bring up right now. And Natalie, so nice to have you in the committee. Glad you're here. And welcome back to Representative Martinez. We missed you the last couple days. Glad you're here. Jason, would you explain this amendment?
All right, thank you.
Why
Madam.
it's so thick?
Yeah, thank you, Madam Chair. Jason Thompson, Revisor's Office. So this is the amendment the KBI told you about. They had a bill in the Senate that would have added some new provisions for the State Bank Commissioner. And they also had some changes for the Attorney General and the State Gaming Agency about their criminal history records. So what's added here is some changes to the fingerprint statute. That's already in the bill, right? And then also 3 banking statutes and 1 Attorney General statute. So that's why it gets so thick. So what's added there on the first page, you see that the Attorney General is moved up into B1. The records you get under B1 are adult convictions, adult non-convictions, adult diversions, adult expunged records, juvenile adjudications, juvenile non-adjudications, juvenile diversions, and juvenile expunged records. So basically you get all the records. That's the broadest one we have under this statute. So currently, Department for Children and Families and KDADs get those records. And the additions here would be for the Attorney General under, that's the Private Investigator Act, I believe, 757B01. Folks who are applying to carry a firearm as a private investigator, so firearms related. Then the AG for 757CO2, that's the Personal and Family Protection Act, the concealed carry issue. And then D, again, is 757B01 and 7B21, so again, private investigators. And then 757E01, I apologize, I don't remember what that is. It's the Attorney General's area, and I can look real fast, maybe, if my computer will work really fast for me. Just because I know it's firearms related, bail enforcement agents. There you go. So it's bail enforcement agents, and it's related to their licensure. That one might not be firearms related. I know we were focused mostly on firearms with the Attorney General, but that one might be a little broader than that one. So, but anyway. Then you'll see on page 2, there's some striking of the Attorney General in a couple places because we've moved them up. There's also striking of the State Gaming Agency because they're moved up under subsection or paragraph 3. And under that section, you receive convictions, non-convictions, diversions, expunged records, juvenile records as well. So they're moved up there from paragraph 4 where you don't receive juvenile records, essentially. So then on page 3, you'll see the State Bank Commissioners inserted. So they would receive the records under that paragraph. These are just adult convictions, adult non-convictions, adult diversions, and juvenile adjudications. So they don't get expunged and some of the other records we were talking about. And then the last addition to the fingerprint and background check statute is there on page 4. This is the State Bank Commissioner for other individuals. And this one's under, it looks like paragraph 6, where you only get, nope, sorry. This one should be under paragraph 7 if I'm remembering right. Yes, where you get adult convictions and adult non-convictions only. So no juvenile records for the bank commissioner under that specific provision. And then, like I said, everything else that's added to the bill is the sections about the bank folks. So you see the attachment, we're adding a definition of applicant, which is used in that statute. Nothing else really changes in that statute. It's just really long. So we have to print the whole thing. That's what the Constitution requires. Page 7 of the attachment has section 2, again, bank commissioner, defining applicant, removing their fingerprint language because it's replicated now in one place. Section 1 takes care of it. And then the last bank commissioner one begins on page 9 of the attachment. Again, removing all the fingerprint language that you see there on page 11 and 12 and just referring you to the statute that was in the bill. So that's what's going on here. You saw a lot of this in the fingerprint bill last year. Same thing, just specific to the bank commissioner. And then the very last statute, it's attachment B, page 14. That is the 75-7B01 that's referenced for the Attorney General. They had to define applicant a little more to make sure that they were getting records for the folks who were applying. Person who has submitted an application for a firearm permit under that section to make sure they were covered under the records provision. I think that's it. A little bit lengthy, sorry. But like they said, they were cleaning up a bunch of firearms related, Attorney General related, same Bay Commissioner related, and this was the place they suggested to do it. So they're asking you to adopt their amendment.
Okay, thank you, Jason, so much for that explanation. So if you all remember, the statute began with the Department of Labor and their fingerprinting because it was basically left out of the fingerprinting statute last year. And then they realized, KBI realized that we also needed to add the Attorney General and the State Bank Commissioner. And so rather than do another fingerprint bill next year, even though I believe we did hear there's a chance we've left someone else out. We don't know, but that's what this is putting it all back, getting it under the fingerprint statute. So I'll go ahead and move my amendment. Do I have a second? Representative Bohai seconds. What questions, what would you like to ask about this amendment? Representative Osman.
Thank you, Madam Chair. I'm still reading through it. This might be an entirely innocuous amendment. He did mention the KBI director, but representative did say that this was coming, and it might be entirely innocuous, but it feels to me as if this is a secondary bill being attached to an original bill without any hearing attached to it. I'm certainly concerned about that, even again, if there's nothing wrong with any of it. Let's start with this question to the revisor. Help me to understand, as the title of it goes, authorizing the Attorney General and the State Gaming Agency to receive more criminal history records. What criminal history records will they be receiving?
Madam Chair, thank you.
Go ahead.
Again, Jason, revisor. Revisor's office, not the revisor, thankfully. So we were cautious with our wording there because Madam Chair's description is correct that the bank commissioner is not necessarily in here. They're being added because their statutes provided fingerprinting provisions. They were amended last year too, and I don't think got moved into the larger picture. So for the bank commissioner, they had some fingerprinting provisions, and I think this is consistent with what they get under current law. They're just moved into this statute. So they're not getting any more records than they already are. With the Attorney General and the Gaming Agency, we're specifically striking them from provisions later in the fingerprinting statute and moving them up. And when you move them up to a higher paragraph, you get more records. So I don't know if this is consistent with what they used to get or what maybe other state or federal law requires them to get, and they've noticed they were not getting what they needed to get. But we were cautious to say they're getting more than what they get under the current provision, right? So they're moving up from, say, paragraph, 4, where they only get adult convictions, adult non-convictions, adult diversions, and adult expunged records. And they're moving up to where they now also get juvenile records. And that may be consistent with the prior law before you adopted this section. It may be something they've asked for since then. But in any case, they're getting more than what's current 224714 says they get. So that's the idea.
Thank you. As in reference to that, can you point to the specific part of the amendment that references where that's located and where they're being moved from to?
Sure. Madam Chair, I'll try to link them together. So the first Attorney General provision, that's the 75-7B04 applications. So that's currently in paragraph 4, which is the stricken language on page 2 in lines 32 through 34. So they're being moved up from adult convictions, the one I just read a little bit ago. They're being moved up from that one up to paragraph 1, where you basically get all of the criminal history, right? Adult, juvenile, diversions, the whole 9 yards. Let's see. The next one is 75-7C05 applications. They are moved up from paragraph 3. That's the strike on page 2, lines 14 through 16. So that's where that one came from. Next one is 75-7B21. That one should also be in 4. Yes, which is page 2, lines 35 through 37. So that's moved up to 1. And then 75-7E03 applicants, they are currently the ones that aren't in. Sorry, I'm sidebarring at the same time. Nope, they're in there. They're on page 6, line 14 through 16. So they're currently all the way down in paragraph 8, which is basically just adult convictions, like basically the minimal amount. So they're being moved way up the list. And then the gaming agency on page 2, that's added to paragraph 3, they're moved up from paragraph 4, like right below there in lines 28 through 31. They're moved up just one paragraph. I think that tracks them all. It is kind of difficult. I agree.
I don't think we have to. I think Representative Osmond's concerns are very valid. And so I'm going to suggest that we have a motion, we have a second, and that we just kind of pause this and let you all take a look more closely at this very large amendment that seems confusing. And we have a representative here from the KBI. And so maybe if you have any questions for him, you could talk to him after this, or he might reach out to you. You know, if you could reach out to him tomorrow, possibly. So I'd like to bring this back kind of first thing tomorrow, but I certainly understand that you might want more time to look at this kind of large amendment. Okay, yes, Representative Barth.
Thanks, Madam Chair. I just have a technical question on page 6 of the attachment A under 26 payroll processing services there. I notice it talks about payroll taxes to state and federal agencies. Is there a reason that local is not included on there?
Madam Chair, so that is just the current statute that we had to put the whole statute in there. And I guess you don't have it in color like the copy I have.
Okay, so this is all current?
Right, so
Okay.
so everything in section 1, attachment A is current law KSA 9-555. So if you want to look at the statute, the additions are the underlined text, right? So the main thing for this purpose is the underlined text B3, applicant in control of a licensee. That's the addition. And I don't think we changed any other definitions in there. So that's all current law.
Okay, that's helpful since
Bet.
it looks different. Thank you.
Yep, so just as a reminder, when we change a statute, we have to print the whole statute. And so that's why sometimes things seem really long when it's only maybe a new definition or something that that's different, you know, that's blocked out. So, okay. All right, well, if that's okay with everyone, we're just going to put a pause. Is that official enough, Revisor? Okay, okay, on this, and we will come back to it tomorrow. I think that's a very good idea. Okay, committee, I would also now like to look at Senate Bill 54 that we heard yesterday. It's third-party litigation, and as you heard from the conferees, that they had come to an agreement of taking out the language from the Judicial Council. And so, and then everyone else seemed to agree. So with that, I have an amendment for that one too. Jason, could you explain this amendment to us?
Certainly, Madam Chair. So, again, Jason Thompson, Revisor's Office. So this does two things. The big one is that it removes all of the reporting to the Judicial Council provisions. So that's the strike in the title, and that's the big strike on page 3 onto page 4. Just removes all of that new language from the bill. The other change is to correct a typo on page 2 in line 39. That of should be or. So we'll fix that while we're in there. That's it.
Okay, committee, what other questions about this bill? Well, I guess we're on the amendment, so let's go ahead and do that first. I'll go ahead and move my amendment. Do I have a second? Representative Williams seconds. So do you have any questions on the amendment, Representative Bohai?
To be clear, this is what the opponents and proponents, or the neutrals and proponents wanted.
The neutral and proponents had changed other language also in the bill that when they came together, but and they were actually okay with the Judicial Council language, but the Judicial Council was hoping to be taken out of it completely, and the proponents, and there weren't really any opponents, but the proponents agreed that that would be a good idea to take them out. They didn't feel like it was necessary. Last year, if you all remember, the Judicial Council was in this bill, but they've adjusted other parts of the bill and now taken out the Judicial Council. Everyone seems very happy with it. Any other questions about the amendment or discussion about the amendment? Okay, seeing none, I'll close. All those in favor of amending substitute for Senate Bill 54, say aye. Opposed, no. Okay, thank you. We've amended Senate Bill 54. Now let's talk about Senate Bill 54. Is there any other discussion on that? Okay, Representative Williams.
Thank you, Madam Chair. I move that we pass out Senate Bill 54 as amended favorably for passage.
Do we have a second? Representative Bohai seconds. I saw her first. Okay. Okay. Any other discussion on Senate Bill 54? Okay. Seeing none, would you like to close?
I close and move my motion.
Okay, committee, you have heard the motion to pass out Senate Bill 54 favorably for passage as amended. All those in favor say aye. Opposed, no. Representative Carmichael, would you like your aye vote?
Thank you.
Okay, thank you very much. Would you please put Representative Carmichael as an affirmative vote? Anyone else? Okay, all right, thank you. Senate Bill 54 is passed on to the House. Okay, I'd also like to look at Senate Bill 222. That was on March the 6th. Do we have any discussion on Senate Bill 222? Representative Carmichael.
We want a brief from the revisor first.
Yes, of course.
I'd be glad to brief on the bill, but it'd be a little biased.
Okay, I'm so sorry. Thank you. Jason, if you would do that, please.
All right, thank you again, Madam Chair. So this is the bill that is a new section that just says, when interpreting a state statute, rule and regulation, or document that has the force and effect of law, a state court or an administrative hearing officer shall not defer to a state agency's interpretation of such statute, rule, etc., and shall interpret the meaning and effect of that statute, etc., de novo, which means with fresh eyes or, anew. The other piece is that after applying all the tools of construction, the court or hearing officer shall exercise any remaining doubt in a way that is consistent with an individual's fundamental constitutional rights.
Okay, thank you. What questions do you have on Senate Bill 222, or are there any amendments? Okay, Discussion, I don't know of any amendments, so let's go ahead, discussion. Representative Carmichael.
Thank you, Madam Chair. Honestly, this is an example of some of the most unnecessary legislation I have ever seen. We had a gentleman from a think tank, the Pacific Legal Foundation, as I recall, who flew in, and he's a very accomplished litigator or appellate lawyer, I can tell from his manner. His organization, I have no doubt, along with others, are traveling around the country trying to make sure that they've eradicated the doctrine of operative construction, otherwise known as deference to agency interpretations. But what he's was concerned about hasn't been the law of Kansas since 2013. Justice Johnson, who by my recollection was probably appointed by Governor Sebelius, a Democrat, said in the clearest language possible that this is an absolute dead doctrine, said it's committed to the dustbin of history. The only thing the man from the Pacific Legal Foundation could say is, well, nothing is permanent. But then he had to acknowledge, yeah, the second half of my bill, where I talk about if there's ever any doubt left, then the court's supposed to follow fundamental rights. But he had to agree, well, yeah, what's a fundamental right isn't permanent either because courts change those things. It's unnecessary. But also, as for the fifth time, distinguished barrister from Finney County pointed out to us, it's really none of the legislature's business to tell judges what rules of construction they ought use. That's the province of courts. My best guess is if some foolish litigant, if we were to pass this and some foolish litigant relied upon this statute, they'd be making a terrible mistake because I think the representative from Finney County is correct, that the court would say it's none of the legislature's business. We use our own rules of construction, statutory interpretation. We decide cases based upon the law and the facts, but you can't tell us what process we should use. So I know we like to pass bills around here, but I really think the better thing for us to do with this bill is to table it. It'll still be available to use maybe next year as a shell or something else, but we sure don't need to pass it now. I'm not going to make that motion right now. I want people to have a chance to talk about it before we go down that road, but at an appropriate time, I hope that I'm recognized again, because I think that's what we ought to do with this.
Representative Lewis.
Thank you, Madam Chair. Yes, I agree with the distinguished barrister from Wichita. You know, we get upset, and rightfully so upset, when courts overstep their mandate and make the law up, and they do that, unfortunately. And I think they should rightfully get upset when we tell them how to do their job. And quite frankly, if I were on the court, I would ignore this law and I would deem it unconstitutional. So, because I don't think it's within our province to usurp the duty of the courts to interpret the laws as using the interpretive tools that they choose, I'm going to vote against it.
Okay, any other discussion? Representative Carmichael.
In the absence of further discussion, I think the better thing to do, I'd like to just vote no and kill it, but I think the better thing to do is just table the bill indefinitely.
Okay, so is that a motion to table?
I move that we table SB 222.
And do we have a second? Second by Representative Vaughn. Okay, so that is a non-debatable motion. Debatable motion. So we are voting if we want to table Senate Bill 222. All those in favor of tabling the bill, say aye.
Aye.
Opposed, no. Okay, I believe the ayes have it, and the bill will be tabled. Okay, committee, that is all we have for today. And that clock's not working. You know, I keep looking at there like, oh, wait, it's still a quarter till.
Me too.
Yeah. Quarter till the next hour. Okay, with that, plan on a full day tomorrow. Plan on not working on Friday, and maybe a long day on Monday also. And with that, we're adjourned. Thank you, everybody. Good discussion.